Well, occasionally farmers and ranchers are required to defend their livestock from trespassing dogs. Many states have adopted statutes that permit dogs to be killed if they're harming domesticated animals. However, it is critical to follow the specifics of the statute, as failure to do so can result in a criminal charge. Joining us now is Roger McEowen with the Washburn University School of Law. Roger, thanks for joining us once again. Certainly a topic that I know a lot of folks in rural America can relate to. Start off, what's a sample of state statutes?
Well, good morning, Janet. Yes, it is. It's somewhat of an unfortunate topic, but it's an important topic for rural landowners and farmers and ranchers everywhere, especially this time of year in the spring season when we have lambing and calving and those types of things occurring. But just to give you a sample of the typical state statutes in the Midwest and in the Plains, for example, Illinois says any owner seeing his or her livestock, poultry, or horses being injured, wounded, or killed by a dog not accompanied by or under the supervision of its owner may kill such dog. The Indiana statute says a person who observes a dog in the act of killing or injuring livestock may kill the dog if the person has the consent of the person in possession of the real estate on which the dog is found. Kansas, for example, says it's lawful for any person at any time to kill any dog which may be found injuring or attempting to injure any livestock, and then you have to pay attention to what the statutory definition of livestock is. Nebraska is similar, Iowa is similar. Most of the state dog kill statutes are very similar in their setup.
So, Roger, what are your observations from this?
Well, as I think people could understand from just a quick listening to me read the portions of those statutes, they all require certain conditions to be satisfied before a trespassing dog can be killed without legal ramifications. Essentially, they require that the dog be, so to speak, caught in the act of doing some specified act to covered livestock.
And now, of course, the dogs can harm the animals, but also dogs sometimes will just herd animals on their own, chase the animals. Sometimes you've also got maybe female dogs on the property and the males are coming over. I mean, does that all fall underneath the same statute, or do they literally have to be harming livestock?
Well, the statutes basically require them to be caught in the act of harming or killing or, in one state, worrying the livestock. However you figure out whether livestock are worried or not, I have no clue. But it's critical in any instance to preserve evidence showing that you've met the statutory requirements, because if you don't follow the statute, then you can be charged with probably a misdemeanor in most states of cruelty to animals, and you don't want that to happen.
Roger, do you have any examples?
Yeah, there are a couple of great cases from Montana in recent years. In one instance, a dog had broken into a farmer's chicken coop, had killed all but one of the chickens. When the farmer found him in the pen trying to kill the last chicken, he kills the chicken, he shoots the dog. And the owner gets upset and says, well, you can't kill my expensive dog to preserve your one lousy chicken that was left. And the court said that's immaterial. He caught him in the act. Another case in Montana, the rancher couldn't prove that he shot the dog in the act of harming lambs. And so it just turns on the evidence in all of these cases. And if you're going to get challenged, you better have evidence to back yourself up that you followed the statutory requirements.
Well, as always, Roger, great insight. Thank you for joining us. Roger McEowen with the Washburn University School of Law, joining us on the phone. Of course, you can go online to washburnlaw.edu for more information.